Collegium system is alien to the Indian Constitution. Collegium system is alien to the Indian Constitution. You tell me under which provision the collegium system has been prescribed. But because the Supreme Court, in its own wisdom, through a court ruling or through a case judgment known as first judge's case, created a collegium. Now that collegium, whether the Supreme Court Collegium or High Court Collegiums, they recommend the name. And government has to do due diligence. Prior to 1991, all the judges are appointed by the government. You are a fine English speaker. You can read the dictionary, whichever dictionary you want to pick up, you read it. What is the difference between consultation and concurrence? Is it same? Constitution says that the president shall appoint, means government shall appoint the judges of the Supreme Court and High Court in consultation with the Chief Justice. And for the High Court, the Chief Justice of the High Court. Now, when the collegium system was introduced, which is alien to Indian Constitution, but government of that day and now also, we very well respect the collegium system until or unless it is replaced by a better system. I'm not going to get into the debate and discussion of what that system should be, but that require a better platform or better situation. What I'm saying is, as long as the collegium system is prevailing, I have to respect the system. But if you expect the government should merely sign the name to be appointed as a judge, just because it is recommended by the collegium, what is the role of government then? What does the word due diligence mean? Because the Supreme Court in its order itself has said that government has to do due diligence. The government has all the apparatus and mechanism to find out the background, the status of a particular person. Because a person who is to be appointed as a judge of High Courts or Supreme Court, or any law judiciary, he should be qualified, good enough. But I don't want to criticize the collegium just because I don't like it. But I just want to point out that there are loopholes, there are things, people are now raising voices that this system is not transparent, bit of opacity is there, and also there is no accountability. So government is doing certain things which government is expected to do. So never say that government is sitting on the files. Then don't send the files to the government. You appoint yourself, you run the show then. So the system doesn't function. Government and judiciary, the executive and judiciary will have to work together. Together we are serving the nation. There's no question of any turf war. There's no question of any fight for supremacy. It's a question of service to the nation. I am bound by the provisions of the Constitution of India. If anything is alien to Constitution of India or the provisions laid in the Constitution of India, this is bound to raise questions. And as a law and justice minister, I don't disrespect any system which is in place, but I will always strive for a better system which can replace the system which is considered not perfect.
Parliament, in a much needed historic step, passed the 99th Constitutional Amendment Bill, paving way for the National Judicial Commission. There was unprecedented support to the above. On August 13, 2014, the Lok Sabha unanimously voted in its favor, with there being no abstention. This House too passed it unanimously on August 14, 2014, with one abstention. Rarely in parliamentary democracy there has been such massive support to a constitutional legislation. This process fructified into a constitutional prescription. After 16 state assemblies out of the 29 states ratified the central legislation, the President of India, in terms of Article 111, accorded his consent on December 31, 2014. This was culmination of a basic, fundamental parliamentary process. This historic parliamentary mandate was undone by the Supreme Court on October 16, 2015, by a majority of 4:1, finding the same as not being in consonance with the judicially evolved doctrine of basic structure of the Constitution. Honorable members, there is no parallel to such development in democratic history, where a duly legitimized constitutional prescription has been judicially undone. A glaring instance of severe compromise of parliamentary sovereignty and disregard of the mandate of the people, of which this House and the Lok Sabha are custodians. Honorable members, we need to bear in mind that in democratic governance, basic of any basic structure is the prevalence of the primacy of the mandate of the people reflected in the Parliament. Parliament is the exclusive and ultimate determinative of the architecture of the Constitution. It is disconcerting to note that on such a momentous issue, so vital to democratic fabric, there has been no focus in the Parliament now for over 7 years. This House, in concert with the Lok Sabha, being custodian of the ordainment of the people, is duty bound to address the issue.